Here's the claim that blew up online. Over the last day, posts and clips started circulating saying lawyers for Donald Trump were physically thrown out of a federal courtroom after a screaming match with a judge. The story said bailiffs stepped in. Voices raised. Orders ignored. Total chaos. It sounds explosive. It sounds consequential. But here's why this matters more than the drama itself. Because when something this extreme actually happens in federal court, it does not stay quiet. Court reporters write it up. Transcripts exist. Judges issue written orders. Major outlets confirm it within hours. And right now that confirmation isn't there. That doesn't mean Trump's legal teams haven't clashed with judges before. They have. It doesn't mean tensions aren't high. They absolutely are. But there's a big difference between documented courtroom conflict and a viral narrative running ahead of the facts. So before we react, before we take sides, we need to do what courts actually do. We check the record. Because once you look closely at what is confirmed and what isn't, this story starts to look very different. Stay with me. The context here completely changes how this incident should be understood. This is where most people get tripped up, so let's take it slow. When something truly explosive happens inside a federal courtroom, when attorneys are physically removed, when a judge holds someone in contempt on the spot, when bailiffs escort counsel out in the middle of proceedings, there is a very predictable, very traceable paper trail that follows. Reporters who cover courts for a living are physically present in those rooms. They're not scrolling Twitter for updates. They're sitting in gallery seats, watching it unfold in real time, often with laptops open and editors on speed dial. Transcripts get requested, sometimes within hours. Judges issue written orders that become part of the public record. Court dockets update to reflect motions, sanctions, or emergency hearings. Legal blogs and court-watching communities analyze the filings as soon as they're posted. Within a news cycle, sometimes within minutes, you see confirmation from multiple independent directions. That institutional machinery is how we know, for instance, when a lawyer gets sanctioned for frivolous arguments, when a defendant disrupts a hearing, or when a judge clears a courtroom. The system is designed to create documentation, because courts operate on records, not on memory or hearsay. That is not what we have here. As of now, there is no confirmed reporting from outlets like Reuters, Associated Press, CNN, NBC News, CBS News, The New York Times, The Washington Post, Politico, or any major legal affairs desk confirming that Trump's attorneys were physically removed from a courtroom after yelling at a judge. There is also no publicly available written order from a federal judge documenting same-day contempt findings tied to that kind of incident. No transcript showing a lawyer accusing a judge of running a kangaroo court in open court. No verified account of bailiffs escorting counsel out while they continued shouting. No emergency motions filed in response to such an ejection. No follow-up hearings addressing courtroom misconduct. That silence matters. These outlets aggressively cover every procedural hiccup, every sharp exchange, every notable moment in Trump's legal cases. They have dedicated reporters embedded in these trials. If lawyers had been physically removed from a courtroom, especially in a case involving a former president, it would not be buried on page 12. It would not be a footnote. It would be front-page legal news, likely leading cable coverage and generating immediate legal analysis across every major platform. The absence of that coverage is not because the media is asleep at the wheel. It's because the event, as described in viral posts, does not appear to have occurred in the way those posts suggest. Now, what is confirmed is something more subtle and more common. Trump's attorneys across multiple cases, civil, criminal, federal, and state, have repeatedly pushed arguments that judges have already rejected. They've raised objections that courts ruled untimely or procedurally improper. They've filed motions that judges described in writing as meritless, legally unsupported, or based on mischaracterizations of law. In some instances, judges have issued sharp rebukes. In others, courts have denied motions with language that borders on exasperation. There have been tense exchanges during hearings, moments where judges cut off arguments, instances where counsel was warned about wasting the court's time. Those things are documented. You can read them in actual rulings, in hearing transcripts, in docket entries. They're part of the public record and they've been reported on extensively. But that's very different from a courtroom meltdown ending in forced removal. The gap between a judge sharply rebuked an attorney's argument and attorneys were dragged out of court yelling is enormous. One is routine, if pointed, judicial management. The other is a rare and extraordinary breakdown of courtroom decorum that would trigger immediate procedural consequences and blanket media coverage. Conflating the two doesn't just exaggerate. It distorts the reality of what's happening in these cases, and it makes it harder for people to understand the actual legal dynamics at play. And here's where the internet fills the gap. What often happens is that a real tension, a sharp exchange, a stern judicial warning, a motion denied with harsh language, gets clipped, paraphrased, or dramatized in a social media post. Someone screenshots a docket entry but adds their own interpretation. Someone else quotes part of a ruling out of context. Then someone adds a layer. A reply thread expands on it. Another account with a larger following retweets it with more detail. A Facebook post turns it into a narrative. Suddenly, a reprimand becomes an ejection. A warning becomes chaos. An order denying a motion becomes proof of a judge losing it or attorneys being hauled out. By the time it reaches general social media, it feels real because it fits an existing narrative about Trump, about courtroom disorder, about legal battles spiraling out of control. It confirms what people already believe or want to believe. It gets shared not because it's verified, but because it's emotionally satisfying. But law does not run on vibes. It runs on records, on transcripts, on signed orders, on sworn testimony, on docket entries that can be cross-referenced and confirmed. Courts are not perfect, and the legal system is far from immune to bias or error. But one thing it does obsessively well is create documentation. If an attorney is removed from a courtroom, there will be a record of it. If contempt is found, there will be an order. If sanctions are imposed, there will be filings. Until there is a transcript, a court order, or on-the-record reporting from credentialed courtroom journalists who were physically present, this incident remains unverified as described. That doesn't mean nothing happened. It means we don't yet know what happened with certainty. And in legal analysis, that difference is everything. It's the difference between informed commentary and speculation, between reportage and rumor, between understanding the system and being misled by narratives that feel true but lack evidentiary support. It's also the difference between holding institutions accountable based on facts and constructing outrage based on distortions. If you care about understanding what's actually happening in these cases, not just what feels like it should be happening or what you hope is happening, then you have to be willing to wait for the records, to demand sources, to distinguish between what a judge said in a written order and what someone on social media claims a judge said. That discipline is not about being overly cautious or dismissive. It's about respecting the actual mechanisms of accountability that make legal systems function. Have you ever seen a legal story online that sounded definitive, only to fall apart once the documents came out? It happens constantly. A viral claim about a bombshell filing turns out to be a routine procedural motion. A story about a lawyer destroying opposing counsel in court turns out to be a mischaracterized exchange during oral arguments. A headline about a judge siding with one party turns out to describe a narrow procedural ruling that doesn't touch the merits. The gap between what sounds dramatic and what actually happened is often vast. And the only way to close that gap is to insist on evidence, to read the actual documents, to wait for reporters who know the system to confirm what occurred, to be skeptical of second-hand accounts that lack citations, sources, or links to the underlying record. That's not gatekeeping. It's literacy. And in an information environment where legal stories go viral before they're verified, it's also a form of self-defense. Let me know in the comments if you've encountered similar stories, and how you go about checking whether they hold up under scrutiny. Now let's talk about the rulebook everyone in federal court already knows. Even if you strip away politics, personalities, and social media noise, there are hard lines that do not move inside a courtroom. These aren't suggestions. They're not guidelines subject to interpretation based on how high-profile your client is or how politically charged the case becomes. They are foundational rules that govern every proceeding in every federal courtroom across the country. Judges run the room. Period. This is not about ego or power trips. It's about institutional design. The judge is the neutral arbiter, the gatekeeper of procedure, the guardian of fairness in that space. Their authority is what keeps trials from devolving into chaos, from becoming shouting matches where the loudest voice wins instead of the most persuasive legal argument. You can object. You can preserve the record for appeal. You can argue passionately, forcefully, even urgently when you believe your client's rights are at stake. Judges expect that. Good judges welcome vigorous advocacy because it sharpens the issues and helps them reach the right decision. But once a judge rules, once they say, "Objection overruled," once they deny a motion, once they issue an instruction, you comply first and challenge it later through proper channels like post-trial motions or appeal. That's not courtesy. That's how the system functions. The alternative is anarchy. If every attorney could simply refuse to follow a ruling they disagreed with in the moment, trials would never finish. juries would be confused. The integrity of the process would collapse. So the law builds in a mechanism. You follow the order now, you preserve your objection on the record so it can be reviewed later, and if the judge was wrong, an appellate court can correct it. That structure protects everyone. It protects defendants. It protects the integrity of verdicts. It ensures that cases are decided on law and evidence, not on who can dominate the room through force of personality or willingness to ignore judicial authority. If an attorney were to accuse a judge of running a kangaroo court inside the courtroom, that is not advocacy. That is contempt. Courts across the country have said this repeatedly, including in published disciplinary opinions and written sanctions. Calling a judge's proceedings a sham, a fraud, or a rigged system while standing in that courtroom is not protecting your client. It's attacking the institution itself in a way that undermines the legitimacy of the entire proceeding. There is a difference between arguing that a ruling is wrong and stating that the judge is corrupt or the process is illegitimate. One is protected advocacy. The other crosses into conduct that courts have consistently held to be sanctionable. Under standards reflected in guidance from bodies like the American Bar Association, and embedded in rules of professional conduct adopted in every jurisdiction, lawyers are officers of the court before they are mouthpieces for their clients. That means respect for the tribunal is not optional, even when rulings go against you. Even when you think the judge is making terrible decisions. Even when you believe your client is being treated unfairly. You can argue those points. You can make them forcefully. But you cannot do so in a way that directly attacks the judge's integrity or accuses them of running a corrupt proceeding while you are standing in their courtroom, subject to their authority. Refusing a direct instruction from a judge, such as being told to sit down or move on, is another bright red line. At that point, the issue is no longer the evidence or the objection you were trying to raise. The issue becomes control of the proceeding. If a judge says, "Counsel, you've made your point, please move on," and the attorney continues arguing the same point, that's pushing the boundary but usually manageable. If the judge then says, "Counsel, sit down," and the attorney refuses, that is open defiance of a direct judicial order. Courts have held, time and again, that such defiance can constitute contempt even if the underlying objection was legitimate. Because the moment is no longer about whether the objection had merit. It's about whether the attorney will comply with the authority structure that makes trials possible in the first place. Judges have broad authority to maintain order. That includes removing counsel if behavior disrupts proceedings or undermines the dignity of the court. But here's the key point. That power is used extremely sparingly. Most judges bend over backward to avoid escalating situations. They warn. They caution. They tell attorneys to approach the bench so they can address the issue outside the jury's hearing. They put things on the record so that if the attorney's behavior continues, there's documentation. They give multiple opportunities to comply before taking drastic action. Removal of counsel is a last resort because it creates significant appellate issues and risks tainting jurors. If a jury sees an attorney being escorted out of the courtroom by bailiffs, it's almost impossible for them not to form opinions about that attorney's credibility or the merits of their client's case. Even if the judge instructs them to disregard the incident, that bell can't be unrung. Additionally, removing counsel can create grounds for appeal based on denial of effective assistance of counsel or procedural unfairness. Courts are acutely aware of this, which is why they tolerate a significant amount of aggressive advocacy, sharp questioning, and even borderline disrespectful behavior before reaching the point of physical removal. That's why claims of physical ejection matter so much. If true, it would signal conduct far outside normal legal conflict. An attorney being physically removed from a courtroom is not a routine sanction. It's not something that happens because a judge got annoyed or because an objection was poorly timed. It happens when an attorney has crossed multiple lines, ignored multiple warnings, and created a situation where the proceeding cannot continue with them present. If Trump's attorneys were removed in the manner described in viral posts, yelling, refusing orders, continuing to shout as they were escorted out, that would represent a level of misconduct so severe that it would dominate legal news coverage for days. It would trigger bar complaints, potential contempt proceedings, and extensive appellate litigation. But again, analysis depends on confirmation. The reason legal professionals are cautious with stories like this isn't sympathy for Trump or hostility toward him. It's not about protecting powerful people or giving them a pass. It's because exaggerating misconduct weakens accountability in the long run. If everything is framed as unprecedented outrage, if every sharp exchange becomes chaos, if every denied motion becomes the judge losing control, if every tense moment becomes attorneys dragged out screaming, then real violations stop standing out. When actual misconduct occurs, it needs to be recognizable as such. It needs to be clearly distinguishable from routine adversarial litigation. If we treat every contentious moment as an extraordinary breakdown, then when something truly extraordinary happens, we have no vocabulary left to describe it. Everything becomes noise. This isn't about minimizing what may have occurred. It's about preserving the ability to identify and respond to genuine professional misconduct when it happens, based on verified facts rather than viral narratives. So the takeaway here is simple. If attorneys behave the way the viral version claims, if they accused a federal judge of running a kangaroo court, refused direct orders to sit down or stop talking, and continued yelling as bailiffs removed them from the courtroom, it would be indefensible under basic courtroom norms. Full stop. It wouldn't matter who the client was. It wouldn't matter how politically charged the case was. It wouldn't matter if the attorneys believed in good faith that the rulings were wrong. That conduct would be sanctionable, and most legal professionals would agree that consequences would be appropriate. But until we see verified records, until we have transcripts, court orders, or credible on-the-record reporting from journalists who were present, that conclusion has to stay conditional. We can say what the rules are. We can say what the consequences would be if the rules were violated in the way described. But we cannot confirm that the violation occurred without evidence. And that distinction is not pedantry. It's the foundation of how accountability works in a system governed by law. If you think courtroom rules should apply no matter who the client is, hit like. Standards only work if they're consistent. Even though this specific courtroom story isn't confirmed, there is a real pattern around Trump's legal representation that's worth talking about. And this part doesn't rely on speculation. It's in court records, disciplinary rulings, and plea agreements. Start with Rudy Giuliani. Giuliani didn't lose his law license because of politics. He lost it because multiple courts found he made false statements to judges about election fraud and failed to back them up with evidence. Judges put that in writing. State bars acted on it. That's documented. Then there's Sidney Powell. Powell filed lawsuits that judges described as frivolous. Courts sanctioned her. And in Georgia, she ultimately pleaded guilty to criminal charges tied to efforts to interfere with the 2020 election. That's not opinion. That's a plea on the record. Look at John Eastman. Eastman was a respected constitutional law professor before becoming central to the plan to overturn the 2020 election. He has since been disbarred in California and indicted in multiple jurisdictions. Courts concluded his conduct violated professional standards. Again, written findings. Even Alina Habba, who represented Trump in the E. Jean Carroll cases, faced repeated judicial criticism. Judges admonished her in open court and in written rulings for violating orders and failing to follow procedure. Those transcripts are public. Each of these lawyers is different. Each case stands on its own. But the common thread is this. Aggressive, media-facing lawyering that might play well on television has repeatedly collided with courtroom reality. And when that happens, judges don't negotiate. They document. That's why legal analysts are cautious about new viral claims. They don't need exaggeration. The real record is already damaging enough. And this is where Trump's legal strategy creates risk for the people around him. He rewards loyalty and confrontation. Courts reward precision, restraint, and credibility. Those incentives point in opposite directions. Do you see a consistent pattern here, or do you think these are unrelated cases? Let me know how you read it. You don't need a screaming match or a dramatic ejection for serious damage to occur in court. Loss of credibility is quieter than viral clips, but it's far more dangerous. When judges repeatedly see attorneys re-arguing settled issues, pushing unsupported claims, or framing every adverse ruling as bias, something shifts. Not emotionally. Institutionally. Judges start writing differently. You see it in phrases like, "The court has already addressed this," or "Counsel again raises arguments previously rejected." Those lines show up in Trump-related rulings across multiple jurisdictions. And once that pattern is on the record, it follows you. Legal analysts have noted this problem repeatedly. Former federal prosecutors, including commentators on MSNBC and CNN, have explained that courts give lawyers a lot of leeway early on. But that leeway shrinks fast once a judge concludes that arguments are being made for messaging rather than merit. That has real effects. Motions get shorter consideration. Warnings get less patient. Benefit of the doubt disappears. None of that violates fairness, but it does change the atmosphere. And defense lawyers feel it immediately. There's also the jury issue, which people often misunderstand. Jurors don't need to see a lawyer dragged out of court to draw conclusions. They notice tone. They notice tension. They notice when judges interrupt or correct one side more than the other. Even subtle signals shape perception. That's why defense attorneys are trained to project control and credibility above everything else. Chaos, even mild chaos, hurts the client. And then there's the strategic bind this creates for Trump himself. He wants lawyers who fight publicly and aggressively. But the more they do that, the less effective they become inside the courtroom where his freedom is actually at stake. Replacing lawyers causes delay and signals instability. Keeping them risks continued erosion of trust with judges. Neither option is good. But this is the situation Trump repeatedly creates. Stay with me. The final takeaway here isn't about Trump. It's about how institutions respond when pressure meets procedure. This is the part that gets lost when legal stories turn into spectacle. Courts don't run on energy, loyalty, or viral momentum. They run on rules, records, and restraint. When those rules are followed, cases move slowly and predictably. When they're ignored, the system pushes back. That's true no matter who the defendant is. The danger in moments like this isn't just bad behavior by lawyers. It's what happens when people stop caring whether a story is verified because it fits a narrative they already believe. If misconduct happens, it should be documented and addressed. If it doesn't, inventing or inflating it weakens the very standards people claim to defend. Trump's legal problems are serious enough without exaggeration. The documented rulings, sanctions, and professional consequences surrounding his legal teams already tell a clear story. Adding unverified drama doesn't strengthen accountability. It blurs it. And here's the institutional reality. Judges don't need outrage to enforce order. They need records. Lawyers don't win cases by performing for cameras. They win by maintaining credibility. And the public doesn't benefit from stories that collapse the moment transcripts appear. So the real takeaway isn't whether a particular shouting match happened exactly as described. The takeaway is this. When legal systems are under pressure, accuracy becomes more important, not less.